What's up, everybody? So Kathleen Zellner the other day posted a link on her X account to a very interesting article. It is a topic that not a lot of people really understand, is how there are so many innocent people still in prison in the United States, and how so many people get convicted even though they are innocent. This is what Kathleen Zellner posted on her X account. For those who think being actually innocent is enough, it's not. And the article is from Harvard Law, and I will link it in the description below so you can go have a view for yourself. Why do innocent people go to and stay in prison? At Harvard Law School, Daniel M.E.D.W.E.D. outlines the tangle of legal rules and procedures that keep wrongfully convicted people behind bars. Tens of thousands of innocent people are languishing in prison across the United States, according to studies cited by the Innocent Project. And while dedicated lawyers, legal scholars, and law students have succeeded in securing the freedom of hundreds of wrongfully convicted Americans, countless other innocent inmates have little hope of reprieve. In his new book, Barred: Why the Innocent Can't Get Out of Prison, Daniel argues that the justice system's procedural rules are largely to blame for the ongoing punishment of the innocent, guaranteeing criminal defendants just one opportunity to appeal their convictions and little to seek relief thereafter. At a recent event sponsored by the Harvard Law School Library, Daniel spoke with law professor Alexandria Natapoff about his new book and the many systematic barriers to overturning wrongful convictions. Daniel described what motivated him to write the book. There is a lot of literature about what leads to wrongful convictions in the first place, he said, including factors such as mistaken eyewitness identification, prosecutorial and police misconduct, ineffective legal counsel, dubious or flawed forensic evidence, and false confessions. But there has been a lot less written about why, when someone who is innocent has fallen through the cracks and been wrongfully convicted, why it is so hard to free that person. A former public defender and appellate and post-conviction litigator at the Legal Aid Society in New York, Daniel spent 4 years running a small innocent project at Brooklyn Law School where he and his students litigated these cases. I just keep banging my head against the wall, he said. It was so hard to overturn these cases, even with a mountain of newly discovered evidence suggesting that these folks were innocent. He also believes that many people in this country are convinced that public defenders spend their lives getting guilty people out on technicalities, and if the innocent person does get convicted, then there are endless appeals. For many people, he said, there is an unjustified faith in the system, and I wanted to write a book that exposes this for a popular audience. In fact, Daniel said, procedural barriers to litigate cases after trial, which are backed into the system, all too often keep the innocent people in prison. When someone is convicted either at trial or through a plea bargain, there are certain hidebound and traditional remedies that are available. They include certain motions for a new trial, but those are usually very time limited and aren't very good vehicles for proving innocence. He added, more broadly, he said, there are 3 sorts of remedies that exist in almost every state. First, there is the direct appeal. What's shocking to me, Daniel, and I did not even realize this in law school, is that there is no right to appeal in the Constitution. There's a reference to the jury trial twice, but there is nothing about the right to appeal. Fortunately, every state gives you the right to appeal your case at least once, he added. But the appeal is not the way to overturn an error based on innocence. You can't bring any new evidence in the appeal beyond what happened in the trial. That is absolutely crazy. If new evidence were to pop up to prove your innocence, you can't bring that to trial. That brings us to the second category, he said. First, habeas corpus, a Latin term meaning you have the body, which derives from the 12th century England. The idea behind it, he said, is you have the opportunity either before the trial or after the trial when you are being detained to force the government to justify why they have the body and hold the government accountable. What's beautiful about this? It's not a vertical remedy. It's sometimes called a collateral remedy or a post-conviction remedy, he said. And in theory, you can bring up new arguments. Here's the problem. Habeas is typically only suitable for constitutional or jurisdictional errors. And in 1993, the U.S. Supreme Court said that a freestanding claim of actual innocence is not recognizable in the federal habeas corpus petition. In other words, it doesn't violate the Constitution to imprison or execute an innocent person. The post-conviction remedy, Daniel told the audience, is the writ of coramnobis, another term descended from the English common law, dating from the 16th century and meaning before us. Coramnobis is a court order responding to important new facts that come to light after trial that shine new light on the original judgment. It's a chance to go back to the original trial judge if you found newly discovered evidence that casts doubt on the integrity of the trial conviction. Sounds great, right? But here's why it's not so great. He said, once they make decisions, judges like the rest of us are unlikely to change their minds. Even in the light of new evidence, it's confirmation bias. And finally, Daniel said, there are executive branch remedies when Chief Justice Rehnquist said in that 1993 Supreme Court decision that actual innocence isn't recognizable by itself in the federal habeas corpus. He said that clemency was a failsafe for the actual innocent. There are many problems with this, according to Daniel, including the fact that executive branch officials are reluctant to look at new facts related to guilty or innocence, seeing that the prerogative of judicial branch as overstepping. In fact, the people who are most likely to get clemency are those who are seen as having demonstrated remorse and accept responsibility. But if you are innocent and ask, how can you be forgiven for something you did not do? So the innocent are less likely to benefit from clemency. At the event, they also discussed the fact that despite centrality of the trial to our adjudicative process, 95% of all criminal conviction in this country are the result of a plea, not a trial. Another barrier to consideration of the innocence is the fact that innocent people plead guilty under the pressure of plea deals and long sentences and the death penalty all the time. Towards the end of the discussion, Daniel was asked about the impact of the reality he has written about our criminal system. What shadow has that cast? The shadow is enormous, he said. I write about and litigate and do reform work in the area of post-conviction remedies and appellate procedures because that's what I know. But the public takeaway is we just have to get it right the first time. We have to get it right at the front end. That is a very good article, and I am definitely going to pick up this book. I don't know if it's out yet, but if it is, I'm going to pick it out. If it's not, I'm going to get it when it comes out. It sounds like it's going to be a very extremely interesting read, but that's a little bit of a look, and maybe I'll do a book review on it when it does come out. But that's a very interesting look as to why innocent people are in prison. And one of the big ones, other than false confessions, is people plead guilty out of the fear of being found guilty, even though they're innocent, to avoid a long prison sentence. Let's just say it's hanging out there on you that you can go to prison for 15 years. Even though you're innocent, there's still a chance in a court of law you can go to prison for 15 years for whatever crime you committed. And let's just say that the prosecution gives you 5 years instead of that 15. A lot of people are going to take that 5, even though they're innocent, to avoid possibly going for 15. It's crazy that that's the way it works, but it is. Let me know what you think. Leave some comments below. I hope you're having a good day, and I will see you again soon.